All right, welcome back to another special episode of The Unknown, and my name is Michael Volpe. I'm in Chicago, Illinois. That's in Cook County, and it's michaelvolpe.substack.com. Richard Luthmann, he's somewhere around Fort Myers, Florida. He doesn't want to know exactly where because he's a weirdo, but I'm almost certain that that is exactly in Lee County, and I am 100% certain that for whatever reason, the folks in Florida thought it was a good idea to name a county after Robert E. Lee, even though he lost the Civil War. And you write at Luthmann, Luthmann.substack.com. And today we have an update in the Jeremy Hales saga. Now, you were one of how many defendants were there? I
believe there were 10 defendants.
I think there were even 11. There are no longer 11 defendants. However, I am sad to report that you are still one of the named defendants. Now, we're going to go through that, but basically, to sum up, this is Judge Zachary Bolitho. Now, because he's a magistrate, I don't remember how they framed it. It's not official because you can ask the district judge. As we go through it, you will see, I'm sure that Jeremy Hales will want to ask the district judge, and it is academic because this wasn't merely a denial. It wasn't close. This was one of the most frivolous lawsuits ever. First, sum up, and then we'll go through a couple of pages. We should mention that you were on with Lisa on Two Leads in a Pod last night. If you folks want to get like the in-depth, you went from start to finish. We don't want to do that because you already did it last night. What we're going to do primarily is show folks just how much propaganda there was on behalf of Jeremy Hales for such a frivolous lawsuit. So first, sum up this, it's not quite an order, this recommendation from the magistrate.
This happens all the time in federal court. You have a report and recommendation from a magistrate judge to the Article 3 judge. The Article 3 judge is the only one that can really decide the dispositive motions, basically a motion to dismiss the case, a motion for summary judgment, a motion that gets rid of the entire cause of action. Mm-hmm. And so Judge Bolitho went through this thing, and there were a whole bunch of motions to dismiss that have been pending for a very long time. And we were wondering, what's going to happen pending. Well, he resolved all of those motions except for the one that I filed a few days ago, and the related issues, and he mentions that, and also except for Michelle Preston's situation with because go to that chart right there.
Right now, before we go on, here is why you were not dismissed. Also not before the court today is the motion to dismiss recently filed by Defendant Luthmann. The clerk of court had entered a default against Defendant Luthmann. Defendant Luthmann has now appeared and moved to set aside the default and sought dismissal. Plaintiffs have recently responded, and the court will address your motion at a later date. Basically, because it took so long for them to supposedly serve you, which you argue they never did, you weren't included in this. Michelle Preston is going through bankruptcy, so anything that she has.
There are additional legal issues that my stuff raises. Right. One of them is, you just said it before, that I have a new document that was filed a few minutes ago on the docket, which moves to strike Jeremy Hales' response to my motion to vacate the default and then dismiss the case. Mm-hmm. But there's also not just the fact that my service issue is different substantially than everybody else's because it's a procedural issue. There's also an issue about the Federal Arbitration Act and alternative dispute resolution, trial by combat.
Because Jeremy Hales, the reason you wanted that is because you were watching one of his videos and he suggested, hey, if you want to do trial by combat, I'll do trial by combat. And so you saw that as a proposal.
A legal offer, and under contract law in the state of Florida, offer and acceptance.
Right, and you accepted that.
Also, equitable estoppel constitutes the contract formation because he can't deny that he actually made the offer. So he may have to actually fight me. Judge Bolitho might get to that.
Or he could admit that it wasn't a real offer.
Yeah, that nothing that he says can be taken seriously on the air. That's the other point that if he
Right.
does. And then the
All right.
third
So
point is a lot of
that's you, but the
okay.
if you're summarizing substantively, it's 45 pages. If you're just
Yeah.
narrowing it down and summarizing what Judge Bolitho did for the defendants that he dismissed, how would you say he described this lawsuit?
Well, it goes procedural to substantive. The procedural issue, and he went beyond this because he didn't want to rest upon this itself, is what we said about a year ago about a shotgun pleading. That the entire complaint, it was the second amended complaint. So he's had 3 tries to try to get it right and to get his story straight. Jeremy Hales has and his lawyer Randy Shockett, and they failed to meet the pleading standards to say something that there were facts that constituted claims. What does that mean? Well, there are a whole bunch of claims that they brought against Lisa and against Bruce primarily, saying that Lisa and Bruce violated these Consumer Protection Acts, the Lanham Act and the Florida Deceptive and Unfair Trade Practices Act, and
And
also
that,
tortious
folks,
interference with business.
FDUTPA is the acronym for the Florida Deceptive and Unfair Trade Practices Act.
It's called the PDUFA.
Now,
That might be the
you and I discussed this several months ago that in reality, what he was arguing was that he was being defamed, but that you believed he didn't want to use that because he couldn't get to actual malice because he would be considered a public figure. So he tried to get cute, and I think by getting cute, it made it even worse. I think he was better off arguing that it was defamation and hoping that somehow he could convince the judge that even at the enhanced status that he could survive. Doing this was worse because the judge was like, "You don't have a product, so as a result, there's no unfair trade practice to have." Do I have that right?
Part of it's that. The other part of it is that the statutes that he selected are about trademarks. So there was trademark infringement type statutes, and so I think he mislabeled what he was trying to sue under under the Lanham Act. So that was a problem. But yeah, by and large, what you're doing is speech and commentary. It's not a product itself. And so that was one of the core issues, and we talked about that in the Daily Beast versus Dan Bongino case, which was a case in the 11th Circuit that were in actually the Southern District of Florida, I believe. But it talked about the same thing. You can't disguise a defamation claim as something else. But
basically,
the problem here is that
without tooting our own horns, most of what we said was going to be a problem was in this recommendation. Judge Bolitho may as well have been watching our videos and taking notes. I don't think he was. I think it's a coincidence because we all understood the law in the same basic way, but he may as well have been taking our notes because everything that you and I said is what he said. Am I right? And here it is. It's quote ill-suited to the requirement of the Florida Deceptive and Unfair Trade Practice Act because this case does not involve a product or service, much less the delivery of that product or service in a manner that was not contemplated under a contract. So there was no contract that was not followed. There was no product that was hurt. There was mean words on behalf of Lisa, you, and others against him that he somehow turned into a product. Do I have that right?
And then that next paragraph was about the $959,000 in damages. It even drives home the point. It's like, how do you claim that amount of damages and come to a damages calculation when you can't identify the product? That's the point. The point of that, you have to show a difference in market value and then an impairment, and that it didn't do that at all.
This $959,000 he got out of his ass. Plaintiffs claim they are entitled to $959,000 in damages for these alleged violations, but the Second Amendment complaint fails to explain how that amount constitute, quoted, the difference in market value of the product or service in the condition in which it was delivered and its market value in the condition in which it should have been delivered according to the contract of the parties. Accordingly, the FDUTPA damages claim against defendant Lee and count 2 should be dismissed. He completely mischaracterized what this law is. This law does not apply to him. And once again, and I think he's good at this, and I think one day Judge Bolitho will be a law professor. He, in effect, is kind of giving this guy a law lesson, that here is how this law works, but you did not meet the requirements of the law, and here's how you didn't meet the requirements of the law. Do I have that right? And I guess every decision where you're doing something like this could be looked at as kind of a law lesson. But go ahead.
Yeah, and I think you're right. I think that this shows that Judge Bolitho knows what he's doing in this area. He put together a good opinion. It was well supported. He didn't stop at the first or second reason why Jeremy was out. He was out 6 ways to Sunday, and he kind of laid it out pretty ironclad. Right. It's going to be tough, like there to be objections to this, but there probably will be, because Randy Shockey gets paid by the hour, so God knows there'll probably be objections and appeals and everything else. But for all intents and purposes, the case is dead, because they used the wrong statute. The Langham Act, the wrong statute, the Deceptive and Unfair Trade Practices Act under Florida law, and tortious interference, a claim, without identifying what consumer product it was, or what actual people got harmed in business.
Right.
So contract
right. Tortious interference. Like, if I go out and falsely claim that you have a terrible product, that's not tortious interference. That is another tort.
That's trade. That's trade law.
Right. Now, if I call your clients and badmouth you, or any client, and convince them to drop you, that's tortious interference. And
there's also, right. Let's say I go to your, you'll see you have a trucking company. I go to your lot, and I know you have to deliver a contract on a certain day. The day before, I slash all your tires. And then I show up the next day with my trucks to do
or
the contract.
You call all my
tortious interference.
Right. Or you call my suppliers, that's tortious interference. In this case, he is arguing that because Lisa said mean things about him on her much smaller YouTube channel, that somehow was tortious interference, when it doesn't meet the elements. You can't just address it to like the potential consumer base at large. There has to be a specific consumer with tortious interference. Now, if your mean things rise to the level of defamation, it could be defamation, but he didn't sue under defamation. Now, way back when this first got started, you and I interviewed Ray Bonebreak, and let's watch.
Mike.
All right, we had a little bit of a technical difficulty, but we're back. So this was me, you, and Ray talking about how frivolous the lawsuit was right after it was filed, to correct whatever wrongs you say about it. Do I have that right?
And I have to ask the question to you, Ray. Now, go to that paragraph there, Mike, paragraph 13. Now, Ray, you allegedly have said all these terrible things about Jeremy Hales, yet he does not know who you are, does not know where you live. Have you ever received a notice from him or from Mr. Shockett detailing all the terrible, terrible things that you said and asked for a retraction and or an apology? Has he done that?
No, he has not.
No. And how long have you been broadcasting, like he says, that you have a YouTube channel? So you're a broadcaster. You're a member of the media. So how long have you been a member of the media?
Well, I've had my channel for a little over 10 years.
So you've been a long-time person in the media. You've been putting out and creating media, and yet this guy does not know your full name, does not know where you live, and did not try to go to the media outlet that's established and ask for a retraction or a correction before running to the federal court to sue you. Is that a correct statement?
Why does he run to his own YouTube channel with 730,000 subscribers and say, Ray Bone Crusher said this, and let me tell you why it's wrong? And that's an important point. he's acting like if you say something bad about me, there's nothing I can do except a lawsuit. And that's, of course, not true. He could just go to his channel. However, he wants the lawsuit for content. Now, what I mainly wanted to show is the level of propaganda that he and his followers have engaged in. So we're going to start with a couple of videos from Jeremy Hales. Keep in mind, all of this hyped up stuff is for a lawsuit that is completely frivolous.
Hey, paint chips. Want to be Peter Griffith? I'm just sitting here at home. Oh, wait, Tank, you're it, because I'm eating. Hales headquarters, one of the most beautiful places in the world, where a federal judge just found you in default of Fed 2. That's right, you lost, paint chip.
Did you lose?
No, I didn't lose. I'm in the throes of battle still, it looks like.
What is he referring to?
That was the clerk's default.
All right, so it wasn't even a federal judge who said that. It was a clerk who entered a default because they asked for a default, claiming that you hadn't responded. Your argument is you were never served. And as we saw, and this was filmed, I think, about a week ago, as we saw what the judge just put into that footnote is that he will deal with all of this. And folks, there's no way Rich is going to lose. The lawsuit is completely frivolous. The judge has ruled on that. Whatever will happen, it will be dismissed like all the rest of the
the eco chamber, the Jeremy Hales ecosystem has been talking today about how I'm still in trouble because of the cyber sex harassment statute or whatever that is. That's the only part of the case that's left that's interesting, but it's really not that interesting because the law is pretty clear substantively that you need to have a private cause of action to be able to sue somebody under a criminal statute, and Jeremy doesn't have that. So that's not even.
Let's watch this.
Possibly one of the greatest Christmas gifts ever that Santa brought. One of the What the Hell ecosystem members is testifying against all of the other members in court.
None of the defendants are testifying. None of them are moles. How many times do you remember him suggesting that one of the defendants, like he just did there, that looks like around Christmas time, how many times do you remember him claiming there was a mole?
Oh, out of control. Like every one
of
his.
A lot. He was lying every single time. No one flipped. No one needed to flip because it was a frivolous lawsuit.
That's right.
All right, now.
Paint chips has been served for the second time in Jacksonville.
All right. Now, first of all, if you serve someone once, do you need to serve them a second time?
No, not if you do it right.
Second of all, is serving someone a big deal?
It's the constitutional requirement of the due process. Yeah,
I know, but did you go out for drinks every time someone got served in a lawsuit that you were involved in?
No.
Did you consider
it's part of the process. Usually, if you're not a total moron, you get it done.
What this guy did, Jeremy Hales, was turn very simple, mundane things into like the biggest deal. Train chips got served. I won this. I won that. And he was hyping things up in a lawsuit that is one of the most frivolous that you will ever see. All right, and let me see if there's any more from him. One more breaking news.
Paint chips just filed a very foolish and frivolous motion in the federal case, and the federal magistrate is not happy. As a matter of fact, Paint Chip's motion mirrors the motion, almost exactly in the header, of the motion that he filed on behalf of his father. Well, the magistrate isn't having it. It's all being kicked up to the federal.
All right. What is he talking about there?
I have no idea, in the sense that he served my father with papers in this case. My father responded, and my father was eventually let out of the case.
But in the middle of it, didn't a one of the motions that were filed ask the district judge to take a look at the ruling of the magistrate?
My dad asked for an article for a Rule 72 objection.
When Hales claims that the court looked at this motion, was so upset that the full Article 3 judge demanded to take action. In fact, wasn't that the point of the filing, to have that federal judge?
That's what Rule 72A allows, and that if Jeremy objects
so not only was he
Bolitho's ruling, if Jeremy he objects to Judge Bolitho's ruling, Jeremy will be using the same rule to bring this up to the Article 3 judge.
Mm-hmm. Right. So he not only mischaracterized it, but he again hyped up what is actually a very mundane part of the process. And that's all he was doing. They never addressed the substance of the case, or they did, but very rarely. They just got deep into the weeds, made things that were mundane seem like they were interesting for a while. And I think the audience finally got tired of it. And that's all they actually did all throughout the process. Now, let me get to my former friend, Megan Fox.
It's the fast way to. It's like speed running cancellation, man.
Mm-hmm. It's gross. This filing. So you will notice that these excerpts, these are new screenshots that came out recently. So being able to add these to the complaint is, I think, really important, right? I mean, these.
All right. She treats it like it's very serious, like it's a big deal. She never once pointed out this is very frivolous. The entire time, all she did was hype it up and pretend like this is a meritorious lawsuit in support of his complete propaganda.
Then, of course, we go through the Jeremy Hales elephant shoe with the Hales. By and through the undersigned counsel, pursuant to Rule 4D of the Federal Rules of Civil Procedure, and hereby respectfully move this court to award expenses incurred in making services and attorney's fees against defendant Richard Luthmann.
All right. So he is going to, for a very long and boring period of time, read the entire motion that was filed, I think, a week to a week and a half ago by Shotgun against you for attorney's fees for allegedly avoiding service. So just a week ago, this is what he was promoting in this utterly and completely frivolous lawsuit. And are you going to lose that motion?
Probably not. He never served me. And one of the prerequisites to getting fees is that he has to mail the package of a waiver of service to the right address, which he admittedly did by his own exhibit. And B, he has to actually serve me with papers after that. So he didn't do either of the things that were the prerequisites. And number three, even in the worst case scenario, they decide that he was supposed to get what he was supposed to get. The value that he put on this was $2,281 plus attorney's fees. He's trying to say that in order to send me a mailing package and then to serve me with papers, it cost him almost $2,500 to figure out how to serve Richard Luthmann. So to mail a package to Richard Luthmann and to figure out how to serve him, and I'm listed on Pacer with my address. I'm listed in the Florida Division of Corporations. My address is not a hard thing to find. I've been listed as Richard A. Luthmann Jr. in the Florida Secretary of State records and the Florida, all Florida records my entire life. Or my entire life in Florida.
I want to explain, this is their strategy, is to cut corners, then use those cut corners to file something that someone like Shizzy bolsters to just create drama out of nothing for a case that's as frivolous as you can possibly find.
It's true. That's frivolous as frivolous can get.
All right, and I just want to play one other thing. This is from...
Why do we browse like this? hunting, clicking, searching. What if we could just...
Not necessarily perfect, but we were, here we go.
Debate because we can. By the way, National Parents Organization, they hate me, love David Rucky. They've stuck a gun to his kid's head. Go look it up. They're huge fans of David Rucky. But this is a father's rights bill because once you get to half, they get rid of child support. And because
I want to go to court if possible, but unfortunately, for anyone who knows who's tried to escape in a relationship like that, it's very difficult to do that. So
that was that, and I think this is the highlight of the video. That was a video we did with, I think, 6 or 7 fathers. And the reason we did it only with fathers was right after things exploded in St. Louis County, Megan did a series of stories, and they were all about women. And so she got some blowback by people saying, well, you know, you're just pro-woman and you're a woman, so you won't even touch fathers. And I remember she either called or emailed me and said, let's do something just on fathers because they're acting like I'm some sort of like feminist and refusing to do fathers. And we invited fathers who had been destroyed by the system, spent hundreds of thousands of dollars. You know, she used to stand up for the people bullied by courts. Now she's standing up for the bullies. And if, I don't know, if she thinks that reading some boring petition from start to finish and trying to fill up 4 hours worth of time, because the longer the video is, the more YouTube will pay you. If she thinks that's better than what we did, so be it. But it's not more valuable to society, I can tell you that.
Well, the problem that she's done is she's taken down the journalism too. Out of the spite that she had for the little tiff that you and her are in, because she's a total narcissist maniac in Jeremy Hales, and she's abandoned the principles of journalism, she's taken down actually very good journalistic material that you two produced together. And that's the real shame, is because there are families that really depend on that.
I agree. And the thing I found is one of a handful of videos that she hasn't yet removed, but I would have had a choice of about 50 some videos. And instead I got a choice of about 4 or 5 to show from the time we worked together. And what we did in St. Louis County and beyond was a very big deal, that she's in effect trying to memory hole, because initially it started just because I wanted to go on Milltown's Best to talk about a story she wasn't even covering. But she's basically mad that I'm calling her out, and she should be mad at herself because she knows that she's unethical. And the evidence is right here. She has spent a year talking about nothing but the hyping up this lawsuit that was frivolous from the beginning, that anyone with any kind of legal acumen would know was frivolous. And her and her cohorts hyped it up. And one other thing that I want to note, let me get this up. So far, now it's been less than 24 hours, but as you can see, all right, I think that Shizzy covered it. I haven't watched that video, but I think Shizzy has covered the case, but most of them haven't even covered it yet. We'll see how they cover it. They'll try to spin it by, right now the spin is, this is only the magistrate. Wait till the district judge gets to it. Magistrates, it's approximately 90% of their recommendations are followed. This is not going to be one of the 10%. This wasn't even close. The district judge is not going to find anything in there that Magistrate Bolitho missed. They were missing most of the elements. I mean, there were like 2 or 3 elements out of all the torts that he said, well, you met that. But that even when he met an element or 2, he's like, but this element you didn't meet. So sometimes they didn't meet any of the elements of a tort. Sometimes once in a while they would meet 1 or 2 elements, but basically they were batting like 3 for 25 in terms of the elements they would need to meet. This is not even close.
It was pretty sad. And one of the things that they were saying on one of the channels today was about how Michelle Preston's in a lot of trouble and how Rich Luthman's still in a lot of trouble. I don't see it. I don't see it at all. And if anything, your article proves that, your article the other day proves that actually, if they're hiring a lawyer who's going to take 40% of what they recover, I think the targets may very well turn into Jeremy Hales and all the moneymakers over there.
Right.
That might
I want
be the one.
to add one thing. This was an article I wrote in November. Even in November, this held true. And we waited until February. He got the decision right. I don't think it's that hard to get to the right decision, but he clearly understood the issues. It was a good recommendation, sort of order. But these motions to dismiss started to get filed in April, and I think by either May or June, they were done. He should have disposed of this in August, September at the latest. He waited until February. He let everyone, I'm talking about Bolitho, this guy, he let everyone twist in the wind. In the meantime, the Hales crew made video after video after video, making it seem like they were winning. They weren't winning. But you should not allow defendants to twist in the wind, even if there aren't YouTube videos being made. You should be aware of that. Obviously, this is a frivolous lawsuit, so you should have addressed the motions to dismiss shortly after they were all filed. And I said it in the article, there's a list of judges who allow motions to sit out past 6 months. They are done in March and I think it's September. And in September, it wouldn't have quite gotten to 6 months. The following March, it would have. And when you know it, mid-February is when he gets the decision. And that's basically when I said right around now is when he would issue his decision because he didn't want to wind up on the list. And I think that's bogus. I don't think it's disqualifying. He's not a great judge, but ultimately, if you get to the right decision, if it takes you too long, it's not great, but that's not the end of the world. He got to the right decision, but he should have taken care of this in September at the latest.
One of the dispositive issues here, one of the things that Bolitho put in the first couple of pages is that there were 10 defendants, I believe, and that 8 of them were pro se. And so that's part of the point. The point is here is when you have a power indifference like that, you have a case like this, it really doesn't belong in the federal courts. And I think that's the message that Bolitho is sending. And I think the only way to really
What do you mean it doesn't belong in the federal courts?
You have a case like this that does not belong in federal court. It's a baseless case, but federal court should be for big time cases. They say don't make a federal case out of this. It should be made for big time cases and controversies, justiciable issues about rights, or issues about big time money. This is not a case about anything like that. This is just a creation of media, polymop. And the judge saw that right away. It's when you have all these people that are there.
Hold on, he didn't see it right away. He saw it approximately a year after it was filed, and about 7 months after the last of the motions to dismiss were filed. He
saw right away in the decision. I meant in the decision. Right. Yeah, he's very early on. And
no,
so I guess when he reviewed it, that's what he saw.
Once he got around to it, but procrastination is bad at work. It's bad at school. It's really bad when the judges procrastinate. It's really bad when lawyers procrastinate.
I don't think the gatekeeper here should be the magistrate judge. I think the gatekeeper should be the lawyer. I think the gatekeeper here should be Randy Shockett. And Randy Shockett should have known that this case is not one that belongs to federal court, the one that was meritless. And I think that he has to be punished pretty hard. I'm still in this case, and my request to the court using its inherent powers for sanctions against Randy Shockett. And those sanctions are not monetary, so I'm fully entitled to them. And that sanction would be an admonishment by the federal court, saying, tisk, you did very bad, and say it publicly for everyone to see, or even a referral to the Florida bar for discipline. And if a judge sends a discipline referral to the Florida bar, you better believe the Florida bar is going to pay attention.
I think there's a good chance of that now because he, only one person, actually 2 people filed under anti-SLAPP. Dave Helm, who was represented by excellent counsel, at least in this case. Chris Gage definitely handled himself well in this case. The reason I say at least in this case, because I don't know what he does in other cases. So I don't want to say he's a great lawyer because I've only been exposed to him in this case. But So they're going to get legal fees back. Now, I actually did want to talk about this. Dave Teschendorf asked for his legal fees back, and the judge said, well, since you're pro se, don't get any legal fees. I think the law should be written in such a way that a pro se litigant, because and let me explain. Anti-SLAPP, so SLAPP stands for Strategic Lawsuit Against Public Participation. It is a lawsuit that is designed to chill your free speech. So these anti-SLAPP laws, which are in 30-some states now, they are designed to help you dismiss of these bogus SLAPP lawsuits quickly and cheaply. And so if you are represented by counsel, as Dave Helm was, you can ask for your legal fees. And in fact, Magistrate Bolitho granted them legal fees. Now they have to go argue with the exact amount of legal fees, but Jeremy Hales will be writing a check. Dave Teschendorf, he said, since you're not represented by counsel, you have no legal fees. I think the law should be written where a judge will say, since you were pro se, we'll say it's $150 an hour and estimate how much time you spent. And then Dave would say, well, it was about 10 hours and $1,500. And the reason I think that is most times these SLAPP suits are against people who don't have the money for legal representation. And so you want to discourage SLAPP suits as much as possible. What do you think of my idea? I think that
I think I go even further. I go in further. I would say that a pro se party is entitled to get the hours back that they spent at the rate that the offending counsel gets paid. So if Randy gets paid $500 an hour and Super Dave spent 10 hours, then he should get $5,000 from Jeremy Hales. That's going to put a real bite into it and cause a real sanction. That's the point. I think that would be the way to do it. That would deter bad actors, and that's what you want to do in a situation. That's what the anti-SLAPP suit does. It's trying to deter bad actors, and so I think that's the smartest way to do it.
I would maybe even go that far, but I think you have to give fees to pro se litigants, because these anti-SLAPP laws need to do as much as possible to discourage this kind of a lawsuit. And Dave Helm argued that I was commenting on your other lawsuit. That is a matter of public concern, and you sued me just because you didn't like my comments. And that is a chill of free speech. And Dave Teschendorf, same thing, only he didn't hire a lawyer. But he should get his money back. Now, last thing to talk about. Does Jeremy Hales have any more potential legal consequences from any of the 9 people who have been dismissed?
Yeah, he could. He could have, they can bring additional sanctions motions.
Can they also bring a malicious prosecution or something to that effect?
They could, but the problem with the malicious prosecution is that you have to show an alleged damages. And so if somebody did a malicious prosecution against them and they didn't hire a lawyer to defend,
Dave was freaked out. But Dave was freaked out. He suffered. Dave at Milltown's Best definitely suffered. I think they all suffered because they were under this cloud, and people could say, well, you've been defaming him. That's why he sued you for months. I think they all suffered damages. Ray, the guy we interviewed, his wife died in the middle of it, and they still wouldn't drop the lawsuit. You don't think he has suffering that he could quantify it?
Yeah, but the question becomes, how do you quantify it at over $75,000? Did they have to go to a psychotherapist, a psychiatrist? Did they take medication? They have to go through therapy and mental stuff. It's a big thing. That's the thing about if they're going to
bring it in state court. Can they bring it in state court?
They could get Jeremy Hales where he's amenable. They could get him in Ohio where he lives, or where he's present. They could tag him with papers there, or they could still get him in Florida because he's in Florida.
But they get him in their state. Is it possible that suddenly Jeremy Hales is facing a lawsuit in Bruce Matskin's home state, Dave Helm's home state, Ray Bonebreak's home state? Could he possibly be facing lawsuits in like 5 or 6 states.
If you're going to argue some type of tort theory, like a personal injury type theory, then sure, there's something called a long arm statute, and that allows you to bring somebody in from another state. The question that he'll probably argue is that, that there's no jurisdiction for them because they don't have the requisite connection or contacts to the state. But they potentially could. They could probably bring a lawsuit against them if they wanted to do that. I don't see those cases as big time cases. They're not big money cases. But if they want to harass Jeremy back the same way that he harassed them,
all right. We'll see. And only 2 of the people were represented in a position, and the 2 were lawyers. But Jeremy might be facing a serious comeuppance. All right, and we will be back.